courts and researching legal and policy issues as they face tribal governance and sovereignty. Lauren works with tribes on building tribal justice capacity, restorative justice models, and child welfare and cultural competent best practices. Lauren additionally serves as a professor for the Tribal Legal Development Clinic at the UCLA School of Law. Prior to joining TLPI, Lauren served as a law clerk for the Native American Rights Fund and the Legal Aid Foundation of Los Angeles. She is licensed in the state of California and currently serves on the board of the National Native American Bar Association, the American Bar Association's Native American Concerns Committee, and the American Bar Association's Tribal Courts Council. Lauren previously served on the board of the California Indian Law Association. Lauren graduated from the UCLA School of Law, where she focused her studies on tribal and federal Indian law, and she is from Albuquerque, New Mexico. And we are very grateful to have her online with us today and for her to be able to share some information that we hope will support you as you continue to develop your tribal juvenile justice system or your Healing to Wellness Court, if that's what you're working on right now. So thank you, Lauren, for joining us today. Also, thank you to the Bureau of Justice Assistance for the support for Healing to Wellness Courts. So I'll just take some time right now, if you can. You want to introduce yourself in the chat box. We're really grateful for all of you being present with us today. Warm welcome from our TA Center to all of you. We've had a really great group of participants over the course of this series, and we're really glad that you're here today. So feel free to introduce yourself. My name again is Anna Rangel Clough. I work here at the Tribal Youth Training and Technical Assistance Center. I'm Muskogee Creek, and I live here in Oklahoma. Our center is located right in central Oklahoma at the University of Oklahoma Health Sciences Center. And I have the privilege and the great opportunity to work with many of the programs that are funded through the Office of Juvenile Justice and Delinquency Prevention in CTAS Purpose Areas 8 and Purpose Areas 9. So if you're joining us from one of those groups, introduce yourself. I recognize some names of participants that are on board. If you're not an OJJDP grantee, please feel free to introduce yourself and let us know where you're joining from and what your program that you're involved in is working on. And I see hello to Cedric and Christine and Bentley. Thank you all for joining us today. All right. Thank you, Deandra. And yes, at the very end, we'll put that link up, and we do appreciate any feedback that you have for us. And we can provide that feedback also to our presenters and help them when they do future presentations. So we really appreciate the feedback, and we hope that you are able to complete that at the end of the webinar. So as I already said, we are the OJJDP Tribal Youth Training and Technical Assistance Center. Our contact information is there on slide 4, so if you download the slides in the presentation for download, you can get our contact information. Reach out to us anytime for training or technical assistance support. We can serve CTAS Purpose Area 8 and 9 grantees, but we can also serve any federally recognized tribe, and we're happy to do so, so feel free to reach out to us at any time. You can visit our website to learn more about resources to support tribal youth. Just visit tribalyouthprogram.org. And I'm going to let Lauren introduce herself and then talk about Tribal Law Policy Institute and give an overview of what we're going to discuss today. Thank you, Lauren.
Thank you, Anna. Hi, everyone. This is Lauren. I'm with the Tribal Law and Policy Institute. Like the Indian Country Child Trauma Center, we're a technical assistance provider. I recognize a few of the participants here. Hello. I see there are quite a few New Mexicans amongst us today. Woot woot. I know many of you are planning to attend the Healing to Wellness Court Enhancement Training, August 28th to 30th. That will be in Albuquerque, New Mexico. So I look forward to seeing you there. TLPI is a Native American nonprofit founded in 1996. We provide technical assistance for tribal justice systems in a range of different areas, including specifically healing to wellness courts. We've been working with healing to wellness courts since 2000, when the movement was first starting in Indian country, and we've been doing this particular technical assistance project since 2009. I've had the privilege of working on this project since 2012, and it's been really exciting because I would say in just the last couple of years, I've seen real movement in the juvenile and the family front. And I think across the board, whether your court's adult criminal, juvenile delinquency, whatever the focus is, we're seeing a stronger and stronger focus on family engagement, which we'll be talking about later today. Here are some links to TLPI's websites. Throughout this presentation, I've tried to provide live URL links where possible. So in theory, you should be able to hover over this link, click it, and it will open a web page to that specific URL. If that doesn't work for you for some reason, in our little pod presentation for download, you'll see that we've included a PDF of this PowerPoint where there's also the URLs there. And if that doesn't work, you can just chime into the chat box or the Q&A, and we'd be happy to send you whatever you're looking for. So here are some learning objectives for today. I was able to tune in to most of Pat Sikukwakiwa's brilliant presentations in these last 4 sessions, and she covered an incredible breadth of the juvenile justice system, as well as philosophical underpinnings to that system. So thankfully, with her foundation, we're going to be diving into the specifics of the Healing to Wellness Court, which is just one component of the juvenile justice system. So today, we're going to strive to understand the context of the wellness court within both the juvenile drug court movement nationally, as well as the juvenile justice system, what those best practices are, what those guidelines are, and that's from a national perspective, not necessarily a tribal one. We're going to identify the primary components of the policy and procedure manual. Because this has been a code-based webinar series, we're going to focus our perspective on the wellness court in this session, specifically on the manual, as sort of a tangential piece of the code. So this is all very like the written form based of the wellness court. And then finally, as a part of that code focus, we're going to specifically look at distinguishing between the different entry models and referral points of a juvenile wellness court. But first, just in case you were interested in what my name looks like spelled out, it's a ridiculous last name, I know. My husband's grandfather immigrated from the Netherlands, and this was his heritage to us, for which I'm very grateful. I'm with the Tribal Law and Policy Institute, which is in West Hollywood, California. So I have the honor of calling you from California. But like I said, I'll see you all in Albuquerque in just a few weeks. All right, so let's dive right in. Why are we doing wellness courts to begin with? Wellness courts are a particular docket model that looks at the highest risk, highest need individuals. By high risk, I mean those that are more likely than their peers to commit a new crime, to reoffend, to become justice involved, however that might look like, compared to their peers who might, get arrested, receive a petition, they are scared straight or whatever it is, the system sort of works and we don't see them again. But for our high-risk individuals, the criminal door seems to be revolving. We see them frequently. They're also high need. This is in reference to their need for services or treatment. They need a lot more intervention than some of their peers do. Specifically with our youth, we see that those that have become involved with the juvenile justice system have a high rate of also having a substance use disorder. A substance use disorder is a diagnosis. This is more severe than just having used substances in the past or even having some kind of dependence. Substance use disorder is a level above that. Amongst youth that are involved in the juvenile justice system, there is an extremely high rate of just general use with substances. It hovers between the 60 and 70% range. But what's really alarming for our perspective is that almost a third of youths that are coming through the juvenile justice system are in need of some kind of substance abuse treatment. So we have the Healing to Wellness Court. For those of you that are not very familiar with the Wellness Court, we often refer to the key components. This comes from the state side. The National Association of Drug Court Professionals and a couple of other groups, as the drug court movement was really gaining traction, sat down to really think through what makes a good drug court. And they had a number of experts and practitioners sitting around the table, and out of those meetings came the drug court key components, 10 things that every good drug court should have. Well, and related to that, when tribes were starting to implement the drug court movement, they found a lot of things that they really liked. The drug court movement, as we'll see later on, really embraces a restorative justice approach. It's non-adversarial. It is looking it has a different philosophical approach rather than the adversarial system, which is very punitive, criminal, punishment-based. It takes a healing, reintegrating approach, which seems to really jive with traditional indigenous conceptions of justice, as well as just a need to help these individuals. But there were some things about the state drug court components that didn't really work for Indian country. There were things that just were a little too inflexible and didn't appreciate some of the jurisdictional components that make up a tribal court, as well as notions of traditional healing. So some tribal judges and some tribal practitioners got together and started thinking about what would make for good tribal key components. And they came up with these 10. I put them in this circle, inspired by Justice Joe Fliesaway of Wallapai, and I think it really works. And so, starting clockwise, we have our team, community, and nation building. You see we flipped 2 and 3. When these were originally drafted, it started with entry and then eligibility, but you don't know who's going to enter your drug court until you know who's eligible to come into your wellness court. So we flipped those. We have healing and treatment, support and supervision, discipline and encouragement, also known as incentives and sanctions, respectful communication, keeping and telling stories, enduring knowledge and experience, and finally, back at the top of the circle, sustained team, community, and nation building. The nation building is what I want to highlight here. This is one of the big differences that came out of the tribal key components as opposed to the state drug court components, because our wellness court isn't just a program. It's a court. It's a component of our tribal judiciary, which is part of our tribal government. And so in creating our wellness court and incorporating all of the healing principles and our multidisciplinary teams, we're not just doing what needs to be there for our youth participants, but also what needs to be there for our community as a whole and part of our nation-building project. And that is really important to me. I found that it's become really important to a lot of tribes as they implement and enhance their wellness courts. And so I want to put that out there in when we're drafting all of our documents for our wellness court, that's a major consideration when we are putting these together. So we'll be going through these, but I just wanted, this is for up in the atmosphere to keep in mind. Other things to keep in mind, just in case you've come across these and you didn't know where they come from. Again, inspired by okay, the adults have their drug court components. We want to make juvenile-specific ones. So the National Council of Juvenile and Family Court Judges, a really neat organization based in Reno, Nevada, they got together and developed the Juvenile Drug Court 16 strategies. These are 16 things that they came up with that are all part of an effective juvenile drug court. There has not been a convention of juvenile healing to wellness courts strategies yet, at least. So these are not necessarily state-specific, but they were predominantly created with states in mind. However, I do think there are some major takeaways for tribes. Some major differences between the juvenile and the adult models are developmentally appropriate services, gender-appropriate services, cultural competence, which includes being competent about our age range. Adolescents are different than adults, that we've learned in our previous sessions, family engagement, and educational linkages. So the juvenile drug court strategies, really, really great. They have been built on, since then, OJJDP, the Office of Juvenile Justice and Delinquency Prevention, your funding agency for those of you that are Purpose Area 8 or 9 grantees. They sponsored a juvenile drug court guidelines. This was a real shift in the documents that are available out there, because the 16 strategies was sort of just like a group getting together saying like, oh, I think these would be good ideas, but it wasn't based on research. Well, now we've had juvenile drug courts for a while, and so they were able to look back at some of the research that has been conducted and say, you know, here's, based on what seems to be working in some of the courts, our guidelines that we want to put in there. I've referenced them a little bit throughout this presentation. Some of them are real basic. They're reiterations of what the strategies have found. But because they were so state-focused and a little general, I didn't make them a central component of this presentation. So that's sort of a different presentation, but I encourage you to look at them if they're helpful. All right, so with that, for the rest of our presentation, I'm just going to sort of meander through the policies and procedures manual and highlight things that I found to be really critical components to consider including in your Juvenile Healing to Wellness Court Policy and Procedures Manual. These are all guidelines, hints, components. The truth is, the most effective Juvenile Healing to Wellness Court is one that is responsive to your community's needs. So I encourage you to, take a look at all of these, understand them, but it's okay to reject something if you've determined that it's not a good fit for your community. All I want is that for you to know what the guidelines are so that you know what you're rejecting or accepting. The worst that you could do is to just copy and paste somebody's word for word without reading it. The best that you could do is to copy and paste somebody's manual that you think did a really good job and meets your community's needs. I've worked with lots of different wellness courts, adult, juvenile, and family. They all are really open to sharing their information. They expect other tribes to copy their materials because they copy their materials. You have a lot of work to do in working with your youth, and so there's no use in reinventing the wheel. With that, this is also, we're in a webinar format, which is a little limiting compared to in-person, but as much as possible, I encourage you to ask questions throughout the presentation. We'll be monitoring the little Q&A pod, but feel free, if anything comes to your mind. You're also welcome to contact me after this presentation. We have technical assistance that we can provide that's always available to you. So this is just the start of the conversation. Mission and vision statement. I'll be honest, it took me a while to be converted to the importance of the mission and vision statement. I thought it was a little touchy-feely. I'm law trained, which has the stereotype of being a little cold, a little legalese, and so I thought that this was just kind of touchy-feely. We don't need to spend a whole lot of time on this. But boy, was I wrong. The mission statement is the grounding statement for the entire wellness court. We're proposing to bring together people that don't normally work together, that may not all have the same boss, that may approach their job with really different philosophies. And our mission statement is what guides us. The most effective mission statements are those that were developed as a group, and so maybe they change every year. Maybe they change every 10 years. But I encourage you to visit your mission statement frequently. It doesn't have to be complicated. They're usually not more than a sentence. And here I just sort of put together an example that I pulled from different tribal mission statements. But this is what we propose to do when we come together. This mission statement exists in a lot of different places, which is why I think we should approach it with care. We're going to include it in our memorandums of understanding. We're going to include it in our contracts. It's going to go out in our participant handbook, so it's available to the public to see. It's also what we use to explain what we're doing to tribal leadership, to community members, to our funders. If you had to describe in one sentence what you're doing, it's your mission statement. Similarly, I think the vision statement has a lot of power. This is where we're trying to go. If we closed our eyes and envisioned the community of our dreams, free from any of the issues that we see, what does that community look like? And so it doesn't have to be a special strategic planning session or a retreat that your team takes, although those would be lovely. I highly encourage it. But if in one of your planning sessions or in one of your, even in a staffing, just any time that you're together, I encourage you to cut out 10 minutes of your agenda and sort of look at your mission statement. Does this still ring true? If it doesn't, let's talk about how we want to change it. It's really, really powerful. And teams that have taken the time to draft it are able to draft the other sections with much greater ease. Steering committee. This is another area that it took me a while to become a convert, but since then I'm a huge advocate. Children and Family Futures is a technical assistance provider for family drug courts. They do brilliant work. They were doing a presentation about governance structure, and by that they meant the different sort of steering committee type bodies that are part of the wellness court, and they had this really complex structure that included a steering committee, an advisory committee, a planning committee. It was like, that's ridiculous. Tribes are way too small. They have way too much to do. They can't be serving on all of these committees, and I still think that's true. But the reason I think that is because most tribal agencies aren't these huge bureaucracies like you might see in the city of Los Angeles. That doesn't mean they can't be. There are tribes that have large bureaucracies. But for most tribes, we have our executives, the heads of our agency, our directors, our supervisors, and then we have our frontline staff. Those are the probation officers, the counselors, the attorneys that are interacting with our participants on a regular basis. But the big difference between the steering committee and the team is what's on the agenda for the meeting. Once you become operational, and if you are operational, then you already know this, when you have your staffing meeting and you're talking about the participants, your participants consume all. They have so many issues and needs for services and things coming up in their lives, need for housing, relationships. They relapsed, all of these things that you're going to need to troubleshoot. You will not have time to discuss the logistics or the needs of your wellness court in those staffing meetings. It just won't happen. And unless you have a steering committee or time devoted to talk about your wellness court, you're going to neglect it. And soon your policies and procedures will be 10 years old. You'll never have revised them, and they just won't reflect what it is you're actually doing in your wellness court. It's also a good way to lose sight of what you're doing, such as revisiting your mission statement, making sure that you have the right team members on your team. Maybe a new need has come up, and suddenly you need to be engaging your vocational training office. That wasn't obvious before, but now it is. It's at the steering committee that we can have those kinds of discussions. Steering committees generally meet about 4 times a year, maybe every other month, but it's fairly infrequent. It's made up of our agency heads. What's important here is that these are the people that can make decisions on behalf of their agency. So if, for example, they need to commit that their probation officer is going to attend every hearing, they need to have the authority to make that kind of commitment. Oftentimes, for many tribes, it's the one and the same person that serves on the steering committee as on the core team. That's perfectly fine. It's the agenda that's different. We encourage that the steering committee have a memorandum of understanding. This is to memorialize who is part of the steering committee and what they've agreed to do. I don't know if this happens in your community, but sometimes there's frequent staff turnover. That certainly happens in my organization. And when that happens, a lot of institutional memory gets lost. And so while we may have functioned perfectly fine on handshaken oral agreements to be on the team, when there's that turnover, we need the ability to transition to say, hey, your predecessor agreed to be part of this wellness court. That means you're a part of it. And our MOU is a tool that we can use to enforce that participation. It also is a tool that we can use to go back to remember what exactly each other has agreed to do. When the presenting officer and the defense counsel agreed to be part of the steering committee, what exactly did they agree to? We maybe spell out some of their roles. Here we put that it should be an appendix to the policies and procedures. This is a real formality. It totally depends on how you want to organize your own internal documents, but we encourage an appendix just so that it's somewhere. Don't lose it. People should have ready access to it. It should be available. It's not hidden under someone's desk or in a safe. It's available so that everybody has a copy. The core team. Okay, so this is the direct service providers that are working with our participants. These are individuals that I think should be spelled out in our policies and procedures manual. I have highlighted a couple yellow. These are team members that have been identified in the research as being critical. That if you have anybody, you need to have these ones that are identified in yellow. It's not that the ones in white aren't important, because they are. There just hasn't been some university evaluation that has verified their importance yet. I would argue all of these are critically important. As we'll be discussing later, there's an entire key component devoted to the judge. The judge is our team leader. They're our convener. They're our coach. They're our team captain. We look to the judge to make the key decisions of the team. We also look to the judge to call the meetings. They're sort of the chairman of the team, if you will. We have our attorneys. I use attorneys here in sort of a loose term. Your court may not use, state-barred attorneys, but instead might just have advocates in some role. So the prosecutor might be just a presenting officer, which may be, a police officer or some other type of presenting officer. Similarly, defense counsel might just be an advocate, but somebody who represents the youth, which can be different than a guardian ad litem. That's sort of a distinction that I want you to look at within your own tribal code. Do you have both a attorney that represents your youth as well as a guardian ad litem who's looking out for the youth's best interest? Oftentimes those are the same thing, but sometimes they're different, and you could potentially have a conflict here, in which case maybe you want both. If you have guardian ad litem, that'd be great to have. Maybe you don't have either. Lots of teams don't have public defenders or any other type of counsel to serve their defendants. Sometimes the judge is looking out for the participants' due process rights, or if the participant wants, they could pay for their own advocate. In a wellness court, we usually only ever see that when the participant is just starting in wellness court, when they're getting admitted, and when they're getting ready to leave, whether it's a voluntary graduation or an involuntary termination discharge. The coordinator, critical. Our wellness court coordinator is so important. They're doing the big thinking for our wellness court, as opposed to the case manager, who is doing more of the day-to-day interaction with the participants. We recently came out with a publication on case management that really dives into the differences between the coordinator and the case manager. And the reason we take such efforts in distinguishing between those two roles is because for most wellness courts, it's the same person that's doing both of those jobs. It's totally doable, but it is important to think of them as distinct roles because one can be neglected over the other pretty easily. Community supervision. This is usually probation. Some tribes have very robust juvenile probation departments, and others do not. I think it just depends on how your juvenile justice system is structured generally. How is juvenile community supervision handled? Is it handled by a case manager or a case coordinator as opposed to a probation officer? If that's the case, then it's that case manager, social worker type person that we want on our team. But this is the person who's not exclusively, but they're spearheading our drug testing, our home visits, our check-ins that are happening maybe every other day, that type of really intense interaction with the participants. That's what we mean by community supervision. Our treatment provider, does your community have youth-specific treatment? Do you have a treatment provider in your community? Is this handled by tribal behavioral health or Indian health services? Or is it instead a non-tribal clinic based in your local municipality or county? Whatever it is, we need, not just want, we need a representative from treatment to serve on our team. Ideally, this is the person that's directly providing the services with those youth. Sometimes the youth are accessing services in a variety of different areas, so we need multiple treatment providers. Sometimes they're seeing multiple counselors within the same clinic, and so we just need a liaison who can come sort of report on behalf of the clinic. But ideally, in my dream wellness court, we have the same treatment provider serving all of our youth participants and then coming to our weekly hearings and reporting on their interactions with the youth for that week. An evaluator, rarely, I would say never, is an evaluator working exclusively for the wellness court. This is usually a person that's serving the tribe generally, helping to evaluate and ensure the fidelity of multiple different programs across the tribe. Sometimes tribes don't employ an evaluator, so instead this could be served by maybe a local university, researcher, tribal college. Maybe you haven't had an evaluation conducted in a while. This could be a consultant that you employ in a limited, fixed contract basis once every 5 years. But we encourage you to consider evaluation as a key component of your wellness court. Cultural advisor. More and more, I see teams formalizing the role of culture on their wellness court as a designated position on the team. Sometimes there are other team members who sort of assume this role in addition to whatever other role they're serving on the team, whether it's judge or attorney or supervision. But other teams are formalizing this as its own standalone role, which can include a lot of duties such as coordinating different activities, language classes, community service, lots of different things. And so if there's funding to help supplement this, I think this is a really exciting component that goes back to our nation building. Oh, I see someone lost volume. Is that true for everyone? Can you hear me? Hello, hello. Multiple attendees are typing. Okay, good. Some of you can hear me. I'll keep going then, but hopefully we can get you back, Harley. Social services, child welfare. I think this is a really interesting position to consider for your juvenile wellness court. Presumably, we are targeting youth who have become involved in the justice system because of their own delinquent act. But nevertheless, there may be a dependency case type interaction also going on. which may warrant the involvement of tribal social services. Maybe their parents have an ongoing case with that youth. Maybe they do with some of their siblings. Or maybe tribal social services is willing to provide some services to the youth and their family without a formal petition being filed. I think tribal social services can have a lot of contributions, including parenting classes, access to children's developmental services, links to education. However, I will caution that sometimes tribal social services can put a family off. They're afraid they're going to get their kids taken away. And so this is sort of proceed with caution in you don't want to scare your family. You want to, part of the wellness court is building trust with this family that you're there to help even though they are court involved. And so social services may be a tool for that, or they may be a barrier. Other service providers to consider including on your team include housing, family counseling, if that's a standalone from social services or behavioral health, medical and dental, maybe you have a clinic that you maybe want to serve. Oftentimes I see them effectively engaged as a steering committee member, but they don't come to the weekly hearings and staffing. And then the school, I put school in green. Engaging the schools is so important for our juvenile wellness court, but it's really hard. I don't know how to do it effectively. I wish I had the magic formula for you. Even if all of our youth go to the same school, which they rarely do, there's not an obvious provider at the school to be the liaison to serve on the wellness court team. The principal, of course, is very, very busy. The counselor is very busy. The teachers are very busy. There's just not an obvious place. So instead, I think some effective sort of, plan Bs have been to engage the school on a steering committee basis, to have some staffing take place at the school to engage, whether it's the counselor, the teacher, or the principal, maybe in a monthly staffing takes place at the school. To ask that the school provide maybe monthly or bi-weekly reports, attendance reports, grade reports, any kind of insight that they can provide about the youth and their engagement with the school system. This may depend on the needs of your youth and how much you want to engage the school. If there are truancy concerns, there's likely grade concerns. As you learn from your treatment provider, the youth substance use disorder often manifests itself in many different ways, predominantly by behavior. And so the way that the youth behaves at school is frankly our best insight to how the youth is doing, even better than drug testing. And so engaging school is important, but it's also important to respect the capacity of your school to engage. Now, again, your youth participants may go to a variety of different schools, and so your ability to engage with some schools might vary from others. So this is going to be an ongoing effort. My apologies up front. It's an uphill battle, but don't give up. People are usually pretty receptive when you respect up front that their ability to participate is limited, but it's a worthwhile effort. Okay, so moving beyond the team now. Team roles. What exactly should we be saying about all of our core team members in our policies and procedures? This guideline 1.2 comes from that OJJDP juvenile drug court guidelines I was mentioning. Here they recommend that the roles of each member of the team should be clearly articulated. The way I have seen that go is that it's a short paragraph. It's a couple sentences about each team member. Anna, I see that there's been oh, look, and Pat has answered. There was a big question from Harley. Would you just interrupt me if you want me to go back to that?
I'll read it out loud. The answer might have gone directly back, but it was a question about what does it mean when you say high-risk youth? My colleagues get confused about high-risk youth and that youth are ineligible for wellness. Or
that youth are ineligible for wellness. So,
yeah.
We can do a little sidebar here. I see that Pat provided a really good answer first about violent offenders. And I wonder, Harley, if that's what you mean. As I was talking about earlier, high-risk youth are those youth that are more likely to become justice involved again. So, they were picked up for a delinquency, and you process them through the system, you issue a fine, and dang it, they committed another delinquent act. They just keep coming back. Whatever we do in our regular adversarial system does not seem to deter this youth from acting out. We need to do something else. As Pat noted, this is different than those who commit violent offenses. Arguably, because Healing to Wellness courts target high-risk, high-use, violent offenders are the most high-risk, high-need. However, federal funding, Congress has put an asterisk on a lot of drug court funding appropriations to limit drug courts from serving violent offenders. And so Pat provides the legalese of that, of who specifically is limited and what they mean by violent offender. It's debatable about whether or not a person could be convicted of a violent offense within tribal court, but nevertheless, there's the definition. I know some tribes that have chosen to specifically target violent offenders as part of their wellness court. These are generally for adults. I think for youth, they're less likely to have that violent offense conviction just by the nature of being youth, but it doesn't mean that they're there. But Harley, I think your point is a good one, that high-risk youth are ineligible for wellness. I think that is a misunderstanding, that in fact the whole point of a wellness court, because we are providing this high-intensity program, we want high-risk youth. This program isn't going to work for kids that just need a slap on the wrist. And so for those that are truly high-risk, they're, but for this wellness court, they're getting shipped off. We want them. And we'll be getting to the screening tool in just a few slides. So thanks for going along with us on that tangent. Team roles. For the spiritual leader, I just put this as an example of what a description of a team role might be. In my policies and procedures, I would also want to include some general expectations for all of my participants. This would include, team members, that all team members are expected to attend the staffing and the hearing. All team members are expected to provide a progress report to the court coordinator before the staffing on the progress of the participant for that week. All team members are expected to, work together in a team format, in a, non-adversarial way. Those kinds of general things. Sidebar, the Model Indian Juvenile Code. I put this in here because Pat was really focusing on the Model Indian Juvenile Code in parts 1 through 4 of this webinar series, and so I wanted to keep the momentum going and just say I love the Juvenile Case Coordinator section. But I also think this is good inspiration for when we're thinking about our team member roles. They provide what I think is a good foundation for what our wellness court coordinator might look like. But if by some miracle your juvenile court system enjoys a juvenile case coordinator, and that's a member of just your court staff, this is a person I would want to engage in my wellness court. So this is another good way to show that you need to look at sort of how your court system operates to see who should be on your team. The team roles I highlighted are the ones traditionally highlighted, but there may be other staff members that fit in some other place, but nevertheless are clearly going to be critical for your wellness court. Team MOUs. This is different than our steering committee memorandum of understanding, but kind of the same. And all it is an agreement between our team members that we're going to serve on the team. A good MOU that I see, they're usually a page, maybe two, maybe three, short and sweet, just identifying the different agencies that are going to be members of the team, providing expectations about what a team member is supposed to do, and then everybody signs. And these become critical when there's that turnover. When there's a new police officer, there's a new treatment clinician, it's going to happen. It happens all the time. And by providing an MOU, you just help that agency with their onboarding process. Here is a quick orientation about what your job includes. It includes participation on the wellness court. Here's what the wellness court is. Here's what we agreed to do. Easy peasy. So highly encourage team MOUs. If this is not a regular course of business for your tribe between agencies, maybe it's not appropriate. If there's a different way of doing things, such as maybe your tribe is real ordinance heavy or resolution heavy, that a lot of these types of interactions come from the tribal leadership, that's okay. Let's go that route. For other tribes, that can be a really arduous path. It can be really difficult to get on the agenda of your tribal council meetings. It can be really difficult to get a resolution passed. And the truth is, these are agreements between the agencies, not necessarily an order coming down from your tribal leadership. So I encourage the MOU, but I far more encourage that you go the route that is the route that you go for any other program in your tribe. Program design. Here we're getting into the nuts and bolts of what our policy and procedures are going to detail so that you can sort of read this chronologically and understand how somebody enters your court and how somebody exits your court. Key components 2 and 3, target population and eligibility criteria. Even though the wellness court model is pretty secure and has a pretty clear idea of who it wants to target, that doesn't mean that you're relieved of the duty to specify who your target population is. And the truth is, this differs from tribe to tribe. Some tribes are really focused on maybe the 15 to 18 range. Some tribes have expanded their target population to include up to age 25, which, as we learned from Pat and I think the second webinar, the adolescent brain it doesn't stop developing at age 18. Some tribes are facing an epidemic from a particular substance, and so they have built a wellness court to attack that specific substance, such as meth or heroin. Some tribes are targeting certain offenses. They want to specifically target, children in need of services or multiple delinquencies. You can't get into the wellness court unless the youth has already, received their third petition or something like that. So I just put all those examples out there to say there's lots of different options. However, each of those options serves to limit the pool of people that can get into their wellness court. It narrows the entry point. And so what I encourage you to do is you need to look seriously at your capacity. If everything is put together, you have all the service providers, you're going to start referring people to your clinician, what is the maximum number of people that you can handle? This is usually bound most by the clinician. How many participants can the clinician serve? And the probation. How many people can the probation officers supervise at any given time? So those caseloads are really what drive it. The courts usually have a bigger capacity than the clinician and the probation. But all needs, it just depends on your staffing levels. So at your maximum, what can you serve? Ideally, courts are around the 20 participant range as their maximum capacity, and most tribes kind of struggle to fill all those warm bodies. And so you may be different. You may have way, way more participants than you could possibly ever serve, and so you're going to need to narrow your entry point. But I would say for the majority of courts, having as wide open of an eligibility point as possible is the goal, because you'll need to work to get warm bodies into your wellness court. It should still be bound by what your community wants out of your wellness court, so you need to look at, who should you be targeting from a meta level. And on the right, we have what are considered the recommendations from the guidelines on juvenile eligibility. Youth with a substance use disorder, those who are 14 years old or older, and those with a moderate to high risk of reoffending. Now, we want a substance use disorder because part of our wellness court model is the obligation to attend treatment. Treatment is a diagnosis that should not be punishment. Only people that need to go to treatment should go to treatment. Therefore, we only want people with a substance use disorder. Just because someone is acting out a lot and clearly needs a lot of supervision does not mean that they would benefit from going to substance use treatment. And so be cautious about who you're putting into your juvenile wellness court. There should be a direct connection between their substance use disorder and the treatment that they'll be attending. Under 14 years of age, 13 and under, has not proven terribly successful. I'm speculating, but I think that under 13, youth just don't have the cognitive ability to meaningfully participate in a lot of those treatments, or to really make the necessary connections about all of the supervision and tasks that you're asking of that youth. And so it's sort of a futile effort, what you're trying to get at, all of these lessons learned with all of the different requirements for the wellness court. It's just not working for under 13. We need to build a different system for them. And then the moderate to high risk of reoffending. Here, we're going to have a really intense level of supervision, no bones about it. We're going to be drug testing the youth twice a week. We're going to be conducting home visits. They need to check in with their coordinator or their probation officer at least once a week, come to a hearing once a week. We are all up in their business. And so they should only need that supervision if they need it. Moderate to high risk of reoffending. Those for whom this is their first offense, there's no reason to think that they would reoffend or that they're not going to be able to abide by some other voluntary treatment plan. Those youth don't belong in the wellness court, at least not yet. So how do we determine that people fit our eligibility criteria? Here is those risk-need assessments. These are the definitions coming from the drug court guidelines. Prognostic risk, a risk of failing to respond to the standard treatment interventions, and need, likelihood of recidivism. So recidivism is a legalese term for reoffending or becoming justice involved again. Other eligibility criteria that courts have looked at is the level of the crime. Only certain offenses may make someone eligible. Their drug use history. Do they have one? Do we know what it is? Can we screen for that? Criminal background. Pat was alluding to the violent offender prohibition. If your funding limits on who you can serve, then you might need to institute a violent offender prohibition. Some courts have bifurcated their funding in order to accommodate violent offenders. So they will get their BJA or their OJJDP funding and say, okay, all of our participants that are not violent offenders will draw down grant funds to serve them, but then those that are will use some other funds to serve those individuals. Residency, do your youth reside in your community? Are they going to be able to access the services that you can provide? Lots of courts want to help all of their youth intervene in all of the ICWA cases, but if your youth resides far away, then they're not going to be able to attend counseling twice a week, and you're going to, you're setting them up to fail. Mental health issues. There's lots of research coming out that drug court participants generally, both adult and youth, are more likely than the general population to have what's called a co-occurring disorder. This means both a mental health issue as well as substance use, and it's important to address both. Old school drug courts used to require that you needed to, quote, solve your mental health issue before you could do substance abuse treatment, or vice versa, you needed to do your substance use treatment, you need to be sober before we could tackle your mental health issues. The consensus today is that those should be occurring simultaneously. You can't do one without the other. However, some tribes just don't have the capacity to serve some mental health issues. They're just too severe, or we need a psychiatrist that that isn't available in our community. And so sometimes you're just not going to be able to help. In fact, if you tried to do substance abuse treatment without that mental health piece, you potentially could be causing harm. It's important to know what you have and what you can and can't do. So some courts just make a flat out, sorry, we can't help with certain types of schizophrenia or those types of issues. And finally, probation status revocation. It's important to know if your youth has other outstanding justice system requirements, potentially in like the county or neighboring municipality. I know actually quite a few courts on this webinar have been really good about working with their neighboring counties to sort of serve as a condition of the county's probation is being in the wellness court. Brilliant, so brilliant. Building that in is really neat. Here's just some sample eligibility criteria that I pulled from some other manuals. For example, youth under 17 or transitional youth 18 to 24, wide breadth of cases, delinquency, dependency, truancy, and criminal, residency requirement, and then finally that final decisions are made from the judge with the input of the wellness court team. Once upon a time, wellness courts took the approach that participants needed to be ready to change, that we can't take somebody unless they're ready to be here. While I think that was coming from a good place, what ended up happening is that courts were using that sort of caveat, that catch-all, to exclude a lot of people that maybe shouldn't have been excluded. We all have biases. We even have implicit biases that we don't even know that we have. And so when people were looking back at the data, it's like, wow, for some reason, all of these people from this family were never allowed to be in the wellness court, but all of these other people who were similarly situated were. I wonder what was going on there. So because of the risk that a court might exclude someone just because they don't like them and for no other reason, we must approach this, voting tendency with caution. Objective criteria is the best. If someone meets all the check boxes, then they should be able to have an opportunity to be in wellness court. That being said, there are always extraneous circumstances. There's things that don't match into the checkbox that you just can't anticipate, and so it's okay for the judge to say, sorry, even though you're eligible on paper, we can't admit you at this time. Entry, legal screening, points of entry. How exactly is a participant going to get into the wellness court? Who's going to be doing the referring? I would say for the most part, most wellness courts follow a similar model in that the referrals are happening at the court level. They're by the presenting officer or the defense counselor. The coordinator is frequently a major source of referral. Here's where I think you need to spend time with your code and how you want to handle that referral process. Do you want the referrals to be happening at the arrest stage? So even pre-arraignment, no court involvement whatsoever, the law enforcement officer is making the referral. At the bail hearing, if you're, this is an adult model, likely your juvenile justice system doesn't have bail. Pre-plea, this is where I see the coordinator making a referral after they've had an ability to take an intake with the participant. Post-plea, that's post-adjudication. I would say that's where the majority of referrals are taking place. And then deferred sentencing, condition of probation, and probation revocation are all post-adjudication, after the fact sort of here's what happens, you've already been sentenced and convicted. Now as part of your sentence, here's what's going to happen. So we'll go through these. I'm sort of watching this chat about the screening system. I have a couple slides later on about the screening, so I don't want you to think we're totally going to skip past that. But thanks for providing those resources down there. So the sequential intercept model, for those of you that applied to a BJA adult drug court grant, this might look familiar. I put this on here just because it popped up in BJA solicitation last year, and I have a feeling it's going to start popping up again. So I just want you to be familiar with it, especially if you are in charge of grant writing for your community. The Bureau of Justice Assistance wanted applicants to identify which intercept they were proposing their alternative to incarceration program. So intercept 1 is that arrest level, the local law enforcement. Like I said, the majority of wellness courts are structured so that it is post-adjudication. So it's in that intercept 3 where the referrals are being made. But maybe it's intercept 2 where your coordinator has identified a participant, and before there's a petition, they say maybe you should try wellness court. So I just put this up here. I'm not going to refer to the intercepts anymore, but I just wanted you to be exposed to the intercept model. It's kind of neat. If you really, flow with logic models, maybe this is lighting your fire. But here it is. Okay, so I have a couple more snippets from the Model Indian Juvenile Code for big fans of the Model Code. These were I put these on here just as an example of how you could structure it. This is all going to be guided by what your code allows. And so if your code has a really detailed process for how cases are to be handled in the juvenile justice system, then you're going to be bound by what those processes are. If your code is a little open-ended, then maybe it's good enough to just have in your code that, like, there shall be a wellness court, look to the policies and procedures. And it's in the policies and procedures that you spell this out. Either way, I think these are good guidance for how we could look at it. This is a pre-arraignment referral model. So this is where that juvenile case coordinator, that golden position, this could also be your wellness court coordinator, any type of sort of like liaison type person that is sort of at this meta level, sees all of the juvenile justice cases coming in, and then can flag them and say, ooh, this one looks like it might be a substance use disorder. Ooh, this one looks like it's in a lot of need of services. Let's flag it and see if maybe wellness court is appropriate. Here's a pre-plea referral. Here the court, the code set it up such that it's still going through the juvenile case coordinator, but they've made a formal recommendation that instead of making a petition, like in lieu of a petition, they should go to wellness court. Frequently, juvenile justice systems don't have a juvenile case coordinator, even though it would be lovely. So this is often being conducted by either the presenting officer or is pitched by the defense advocate. So I would say that's more often than not what's happening. Sort of a little sidebar. This is a snapshot from the OJJDP Tribal Youth and Training Technical Assistance Center Tribal Juvenile Healing to Wellness Court Handbook. Sorry for that mouthful. But this is the resource that Anna and her group developed to help build your policies and procedures model. And they've got a number of really great resources on here. But here they pointed out different things that you might want to codify in your tribal code about the wellness court. And Pat and I had a discussion about this. I highlighted just a couple of things to think about. I'm of the school of thought that I wouldn't codify all of these things. I think it's good to establish the wellness court. And in most codes that I've seen, there is a judicial code that establishes, like, okay, hey, here's the tribal court. We're a court of general jurisdiction. We also have an appellate court. And then that's where I would put, we also have a wellness court. The wellness court is not just a program, it's a court, and so we want to establish it in the same way that we establish all of our other courts. But I might end it there. I hesitate because I think once you start codifying your entire policies and procedures manual, you just cemented it in stone, making it really difficult to modify. The policies and procedures is intended to be a living document. As you work with your wellness court and you spend time with it, you're going to see that things need to be changed. You're going to have different team members. Your participants are going to have different needs. A new drug is going to come into your community and totally upend everything, and you're going to have to start over. And so you want some flexibility. When you start codifying things, the whole point of the code is that it's a little difficult to change so that you have some reliability for that it's going to be there. So I would say definitely establish your wellness court, but then think about what else you want to do. Some courts will codify the fact that there is a policies and procedures manual and that will guide the court. They might also codify who the team members are, what agencies need to participate. There might also be caveats on the rules of evidence. Because this is a non-adversarial court, the rules of evidence won't apply. Maybe they'll codify what incentives and sanctions can be used within the confines of the wellness court, and what happens when there is a successful or unsuccessful discharge. I think those are all really reasonable things to codify, but they're also not necessary. It just kind of depends on what your tribe's approach is to the code. So I put that out there. I apologize it doesn't have more guidance. It's just that there's a lot of variables. Interjurisdictional referrals. I know that a number of you are doing this, which is like, oh, it's so exciting. We're working with a couple of tribes in Oregon, actually, that are receiving most, if not all, of their referrals from the county. So there, all of the youths have a delinquency case originating in the county. You know, it happened on non-Indian land. But they've been able to work with the county and either have the wellness court serve as sort of a, quote, condition of probation, or it's their full probation. That, like, supervision has been transferred to the wellness court. There's lots of different ways that you could look at this. In California, we've seen a number of joint jurisdiction courts arising where the county and the tribe both share the bench. So you have two judges, and between the two judges, you have all the jurisdiction you could possibly need. You might just have, like in New Mexico, I know, a lot of the probation officers have really good relationships. And so especially, you know, between Santa Fe and Taos, there's quite a few pueblos and quite a few different cities that outside of Indian country, so it's really easy to cross into different jurisdictions. So probation officers will just call each other up when they come into interaction with who they know is a participant in another court. Interjurisdictional relationships is a whole other presentation. It really lights my fire. I encourage you to check out, as part of our attachments, I've included a sample transfer memorandum of understanding. We're currently working on this, so this is also a living document, but this will just give you an idea of some of the sort of things that you can lay out with another jurisdiction to maybe facilitate getting cases that you otherwise wouldn't be able to get because they're happening in another jurisdiction. But nevertheless, that's where your youths are. That's where the need is. So here's that screening and assessment information. This is the other half to the legal referral. When we are admitting someone into our court, we need them not to just be legally eligible, having a delinquency petition or a petition in another county, but they also need to have a substance use disorder. How do we determine that they have a substance use disorder? Well, they're screened and assessed. The screening tool is usually a really basic form. Sometimes the substance abuse counselor conducts the screening. Sometimes it's the coordinator or the probation officer. You don't have to be clinically trained necessarily to conduct the screening. You do, however, need to be clinically trained to conduct the assessment. This is a more in-depth look at a person's background, including their substance use, but also some of their family background, some of the other things in their lives that may be contributing to their substance use. So this needs to be worked out with the substance abuse counselor. This is also where things can get a little tricky, logistically speaking. We encourage, as part of the key components, a quick turnaround with this assessment. What was happening in the early days of wellness courts is people would be referred to an assessment, and it might be a couple weeks or a month before there might be an appointment. Or it was up to the youth to schedule the appointment. Well, this is a youth that not only has a substance use disorder, but also is has been criminally involved or delinquency involved. They might not keep their appointment. They might not even make that first appointment. It's our job to make sure that they get that assessment done. In my dream wellness court, the screening and assessment is conducted in the court at the same time that the youth is there for their arraignment or their initial hearing or their sentencing hearing. It's happening that exact same day in that exact same place so that there is no transition time whatsoever. Some courts, the substance abuse counselor is located in the same office, and so this is easy peasy, no problem. Most places that is not the case. The behavioral health or substance abuse is its own office with its own system and its own way of doing things. That's okay. It's our job to figure out how to meld those two systems. On this next slide, we have a couple of different recommended screening tools. In our Wellness Court Handbook, they've identified the CRAFT tool as being specifically found to be effective for Native adolescents. That's kind of a big deal. I found that a lot of counselors sort of have their own personal preference for the tools that they like to work with, and that they've also found to be effective for their own community members. And so I would ultimately be guided by what my counselor wants to work with. They're the ones that need to use it. They're the ones that use this information to build the treatment plan. But if you're starting from scratch, these are some good tools, and then it looks like Anna and Pat provided some other really good tools and resources in the chat box. Structuring your program. What happens when they're in the wellness court? We have phases. The phases are intended to help a participant sort of break down the mountain of requirements that we're going to throw at them into some bite-sized pieces. There's no research out there to show how many phases are effective, how to structure them, or what should look like. So we just have some guiding principles. Generally, courts break their phases into 4. This seems to be really appealing in Indian country, as 4 is a sacred number. But you can pretty much do whatever you want. But here are some guidelines. This is a list of different things that are usually part of the wellness court requirements. We want them to go to treatment. The treatment plan is individualized, and so what will be required for one participant may differ from another participant, but usually the intensive outpatient program is the same for most participants. So that might include a couple of group counseling sessions, some individual counseling, and maybe participation in a curriculum-based program. Intensive supervision, this will be the same for all of our participants. Especially for our youth, we might institute a curfew, check-in with one of the team members, drug testing. There's lots of research to show that drug testing is a really effective tool as part of our wellness court. It should be conducted at least twice a week, and it should be randomized as much as possible. I work 9 to 5, all of my colleagues work 9 to 5, and I really like working 9 to 5. However, most substance use does not take place Monday through Friday, 9 to 5. It takes place at night, and it takes place on the weekends. This is where our probation and our law enforcement become really critical team members, because in order to help our youth with their substance use disorder, we need to hold them accountable for when it counts. And so having drug testing and home visits on nights and weekends is one of the best ways to do that. As part of our wellness court requirements, we'll also include pro-social activities, cultural activities, family services, and many wellness courts include fees. The fees are sort of this kind of funky area where research has shown that having a fee is good. It makes people feel accountable and that they have buy-in, sort of that, like they don't want to waste the money that they've spent, so they're more likely to complete the program. However, you don't want to have charged so much money that suddenly people can't graduate because they owe the court hundreds and hundreds of dollars. So some courts will do maybe like a $25 fee per phase. Other courts there'll be no fee, but if you challenge the results of your drug test and it turns out it was in fact dirty, then you have to pay the fee for that drug test. Different things like that. You just want to be cautious that you don't overwhelm anybody. Here's an example of some of the phases. There's quite a bit of research out there to show what should be done when. For example, many of our youths that are coming in with a substance use disorder, they're likely actively using. And so to ask that they be going to school 100% of the time or have a job is unrealistic. What we want to do in that first phase is just stabilize. And so all we're looking for is not even sobriety, it's honesty. Can you just tell me if you're high or not? Is this drug test going to be positive or not? And then we'll work up towards getting regular school attendance. We'll work up towards getting a significant number of sober days in a row, those types of things. And so building up to realistic goals. In your policies and procedures manual, I think it's really good to detail what the expectations of community supervision are going to be. This is important not just for your participants, but also for your team members. What specifically are we going to be asking of our participants and our probation officers? On here I have drug testing protocol. Ideally, you have a drug testing protocol already in place with your probation department. If you don't, there are quite a few resources that already have a drug testing protocol spelled out. So don't feel like you need to invent what a good drug testing protocol is. This has been hammered out by a lot of courts, and so if you need any resources on this, we'd be happy to share because it's pretty straightforward. There's a number of regularly used labs within Indian country. I know some courts have really strong preferences for one or the other, and so I think it's just important for you to find one that works well for you, that is reasonably priced. Usually drug testing is about $5 to $8 per test. A lot of tribes are able to just do the regular testing in-house and then send it out to a lab only when one is contested. It's important to be testing for the substances that you know are regularly used in your community. For a lot of our youth, it's marijuana, it's alcohol, and so we definitely want to make sure we're testing for those. But you might find that there are other random substances that appear, especially for those of our participants that are heavy-duty users. It's not uncommon for a participant to switch substances while they're in the wellness court. And so that's another thing to just keep in mind. This is an excerpt from the guidelines concerning case management. As I mentioned, we have a publication devoted to case management, but I just wanted to put this on here because I feel like case management is sometimes neglected, and it's so incredibly important. This is where the magic happens for our participant, where we're able to sort of bring them back to the light by providing structure and support. The accountability that comes from our drug testing and home visits feels really adversarial, but it's important because it's part of this structure that it helps a participant find new day-to-day stability, and it's the case management that's the honey for for a lot of this new life that we're building. So there's lots of really great materials on what makes a good case manager. As I mentioned, the coordinator frequently also serves this case management role. So it's a really special person that has this role. I imagine that many of you on this webinar are in this role. I'd be happy to share more resources on here, but I just want to make sure it's detailed in our policies and procedures, even if it's in this limited way. Judicial supervision. I mentioned the judge has their own key component that's really special. We also have a publication devoted just to the judge. Here in the policies and procedures, I don't think it's terribly important to go through the philosophical approaches that the judge should take. I do think that this is the place where we document how often our court is going to be meeting and what the structure of those meetings are going to be. The guidelines recommend that court take place at least every other week, so bi-weekly. Most tribes that I work with have court every week, at least for the first couple of phases. As the participant progresses through the phases, what tribes will frequently do is they'll turn down the frequency as sort of like an incentive for progressing through the phases. If you make it to phase 3, then you only have to come to court every other week. And when you get to phase 4, you only have to come to court once a month. Isn't that great? I think that's a great way to do it, but when we start out, it's as frequently as we have the capacity to do. Some courts just aren't able to employ a judge for that much, and so it has to be biweekly. Same for other team members. That's okay. I think that's just fine. Also in our policies and procedures, we should detail what the expectations of our team members are for the hearings and the staffings. Who needs to go to what meeting when. Ideally, the staffing takes place immediately prior to the hearing. So usually you'll see like, okay, the hearings are every Wednesday afternoon at 3, and so our staffing is at 1 p.m. There's a lot of science about what makes for a good hearing and a staffing. You want to make sure that you devote enough time to discussing the progress of the participants. What were their challenges for that week? What were their strengths? What are we going to focus on? What incentives are we going to provide? What sanctions are we going to provide? What additional support's needed there? But you don't want to spend too much time. Again, we want a big capacity. We want to serve as many participants as possible, but we can't have a 6-hour meeting every week. We've got to do this efficiently. That's where the progress reports come in. Courts need to be efficient at how they are addressing each participant, but still in a comprehensive and holistic way. It's magic when it happens well. It depends on all the team coming together in just the right way. We have some sample progress reports that we'd be happy to share about what information needs to be on there. The hearing has its own sort of magical combination. Some teams keep sort of the same courtroom structure. The judge sits on a bench. We have the 2 tables. That's perfectly fine. Sometimes your courtroom that's built in, and that's just the way it has to be. I encourage that all of the team members attend the hearings as much as possible, and that all of the participants are able to listen to each other's case. There's a lot of really good that happens when participants are able to see the judge interact with the other participants. Some tribes will forego the traditional structure of the courtroom and all sit in a circle. Some tribes have each team member speak during the hearing. I think that can be kind of nice, but again, time becomes a factor. Some tribes have the other participants speak. I think that can be really neat, but I would caution you that sometimes that might veer off into unhelpful areas, and so just something to be aware of. And I say all that, there's a lot of different ways that you could structure the hearing. Room for creativity. I put on here just a couple of considerations for your manual about how you want to handle the hearing. Because the wellness court is a non-adversarial process, we're foregoing a lot of the formalities of the adversarial process, including formal due process rights. I encourage you to look at your code and consider what you want to spell out. Usually it's in the participant contract that we spell out like, okay, you're going to have a formal hearing, but maybe you're not going to have a counselor there for every hearing. Or maybe you are going to have a defense advocate, but it's this different liaison advocate as opposed to who's been your counsel in your other delinquency proceedings. We encourage that each participant have a right to be heard at each of their hearings, but it's not with the formal motion process that might be in the rest of the court. The advantage we have on the juvenile side is that our juvenile justice docket is already a little less formal than the adult side, and so maybe we don't have to modify much. Admissibility of evidence. So one big question that always comes up for many people in wellness court is that, man, we're drug testing them twice a week. Inevitably, one of those drug tests is going to be dirty. Are we going to issue a new petition for possession when that happens? The short answer is no. What happens in wellness court stays in wellness court, or so the saying goes. The advantage of wellness court is we're having these frequent hearings, and so we can address those sort of little delinquencies when they happen. We don't need a new petition. We'll sanction that dirty drug test as we determine, necessary and relevant within the drug court. Maybe the youth needs to write an essay. Maybe they need to explain to the court why it was dirty. Maybe something was happening in their life and they're just dealing with the relapse and they just need support from the wellness court right now. We'll deal with it then. Of course, some delinquent behaviors rise to the level of crime and can't be handled just within wellness court, such as if there was a violent burglary, for example. A new petition may be necessary then. It's sort of within the confines of the wellness court to make those determinations. But generally, I would say drug-related offenses that happen within wellness court are the whole reason we're in wellness court to begin with. And so it's not going to be a new petition every time, which means that they're not admissible to be evidence for other petitions. As I mentioned, incentives and sanctions. This is definitely an area to detail in your wellness court, as I'll show in the next slide. There's a really brilliant philosophy around what makes for effective incentives and sanctions, but it's generally a balance between notice, having the participants anticipate that, look, if you mess up in wellness court, if you don't go to your hearings or you don't go to your appointments, you're going to get a sanction with incentives. If you do what you need to do, if you test clean, the court's going to give you a little incentive for doing well. So this little circle are different things that we should be considering when we approach incentives and sanctions. For those of you that are attending the enhancement training in Albuquerque, we'll have a whole session just on incentives and sanctions that I highly encourage you to attend because there's just a really neat different considerations. You'll also find that when you're in your staffings and hearings, you're going to spend a lot of time on these issues just because it becomes really complex with some of your different participants about how to make them individualized but also fair across the board. It's an art, and I wish you good luck. The best thing I think you can do is to provide a little bit of framework, though. So these are snapshots from the Juvenile Wellness Court Handbook, and I think this is a great thing to include in your manual. What are the types of incentives and sanctions that your participants can anticipate? I would just include a list, just like this. So these are the types of things that you might get. It doesn't mean that we can't think of something else that's not on this list that might be relevant for a participant, but here's the types of things that you could anticipate. Judge Flysway always has a really good story about how he had one participant, and for that particular participant, going to spend time with Aunt Edna and listening to her stories was a sanction. It was the last thing that they wanted to do on the whole earth. And so he would sentence them, you need to go spend an afternoon with Edna and, chop her firewood. And for other participants, it was the best thing ever. They loved hanging out with her and listening to her stories and eating her cookies. And so for them, that wouldn't be a sanction. It would be an incentive. And so that's a kind of extreme example, but that's what we mean when we think about individualized sanctions and incentives. We want to do what we think is going to most likely modify their behavior, and that's going to be different for different participants. But for the purposes of our policies and procedures manual, I think providing notice about what kinds of things it could include is best. This also has the advantage of giving us a little guidance about what we can be doing. I think courts, especially in the early days, were guilty of just over-relying on jail. Jail is what we know in the adversarial system. It's what we automatically think of when we think of punishment. And whoops, all of a sudden the wellness court was just another angry adversarial court sentencing everyone to jail. We just ran out of time, and so instead of having to be creative every week on the spot, here's a list that we can choose from. Family engagement. I wanted to do just a little sidebar on family engagement because, as I mentioned, I feel like courts are getting really good at this, but I also think it's one of the big challenges for juvenile drug courts. When I think about, what's the difference between juvenile and adult courts, it's not the obvious one that, we're working with youth, they're under the age of 25, but it's that they have these caregivers in the background. I would say, and Judge Christine Williams of Shingle Springs often points this out, that she's never seen a truancy case where it was just truancy. And I have a feeling that that's true for our youth with substance use disorders. It's never just a substance use disorder. There's usually something else going on. And that's the real challenge of our work in juvenile wellness court, is working with the families and all of these other stuff that's going on. Frequently, our parents have their own issues that's going on. A lot of times what they were finding in the original juvenile drug courts, which I think is still true today, that parents were not bringing their kids to juvenile drug court because the parents had their own substance use issues and were afraid about being found out themselves. That's going to be an issue for us, and our job is to provide a infrastructure that's supportive of those parents so they feel safe coming into the juvenile wellness court, even if they do have their own issues. They often have their own poor parenting skills. I think you'll find a lot of our parents of our youth are kids themselves. They weren't taught how to parent. They don't know what they're doing. They need help. There's also just general instability. We might see complex families, different moms, different dads, boyfriends and girlfriends, half-siblings. These are all things that we need to navigate. We always highly encourage in our family wellness courts with parents that on our weekly progress reports, we include who the partners and other children that are living in the house. I would encourage the same for our juvenile wellness courts. We need a snapshot of what the family is going to be, and it's not going to be just the nuclear family. Who are the supportive caregivers besides the parents? Are there grandmas, aunties, and uncles that are also going to be taking responsibility and getting the youth to court each week? We want to know who those people are. The more often that caregivers attend hearings, the less often that youth were later absent from school, missed their own treatment sessions, or even received sanctions from the court. I use caregivers in the really broad term of biological parent, grandma, custodian, guardian, auntie, uncle, whoever is taking that prime responsibility, whether there's a legal designee or not. It's important to be cognizant of who does have that legal parental responsibility because, as I'll show in the next slide, we may need to use some sanctions to motivate whoever that caregiver is. But if the youth has an advocate in their corner, well, we want them in our corner too. So here's some honey strategies for encouraging family engagement. I don't know if any of you have ever had a trauma-informed walkthrough in your court, or sometimes called the trauma-informed audit. But one of the big takeaways of those is that a lot of our buildings are kind of scary looking. They're even triggering in some ways. And so it's upon us, it's our responsibility to make our environment as welcoming as possible. I think the same goes for family engagement. What can we do to help support the whole family? Can we offer support groups, parenting classes? Can we make our hearings at times that don't interfere with parenting work schedules such that they can't attend the hearings? Is there any way we could do night hearings or early morning? Incentives. It might seem patronizing or even childish, but offering incentives to parents for their engagement has proven really effective. And it doesn't have to be patronizing, but I think it can be really endearing to say that, we recognize all of the work that you have to do, Mom and Dad, to help support your youth in this program. Education about youth substance use. Just in preparation for this webinar, I had to do a lot of education, and there's a lot of really interesting information that's not intuitive. Anything that we can do to help our parents understand the maze that they're entering now with a youth with a substance use disorder. Okay, vinegar. Sometimes our parents just won't show up, and now our youth is getting in trouble because they're absconding. What are we going to do? The Model Juvenile Indian Code has a couple of different provisions where they address this. I think the Model Code does a really good job about using petitions, contempt orders, and detention as areas of last resort. And so they build a structure of how to deal with caregivers who don't comply. I use this just as an example. It is within the realm of the juvenile wellness court to exert jurisdiction over the family, including the caregivers. And I think you'll find that even though we're a juvenile wellness court, we are serving the whole family. And so we need to treat the caregivers as a critical component of our focus just as much as the youth. Got a couple other sort of quick takeaways here before we wrap up today. Confidentiality is a huge topic. It's critical that all of our team members remember that when we discuss the substance use treatment and even presence of a substance use disorder, that's confidential and stays within the team. However, in order for a participant to be in the wellness court, they need to sign a waiver of confidentiality so that the team members can talk amongst themselves. If a participant won't sign that waiver, they can't be in the wellness court. And so that's why wellness court is a diversion. It's an alternative. If a participant can conceivably opt out by failing to sign that waiver. They can revoke the waiver at any time. That's within their right, and that's a right that we need to communicate to them. But when they do, that means they can't be in the wellness court and they're effectively terminated. We have a whole bunch of resources just on confidentiality. I know a lot of treatment providers are really hesitant about this topic. They're afraid that they are not allowed to discuss a lot of things that come up in substance use treatment with their team members. That's true, but only to an extent. Within the wellness court, it is not only acceptable, it's necessary that a participant discuss the necessary things about whether or not the participant attended treatment and how they're progressing to the other team members. It's important to remember that the HIPAA, the Health Insurance Portability and Accountability Act, the whole purpose of HIPAA was to encourage the communication, not to stop it, and yet I think a lot of team members see HIPAA as just a big red stop sign. We have resources to help you navigate this if that's what you want, but I know it's a whole can of worms. So I put it out there. It's actually easy. Don't be scared, but I know people are scared about it. Development appropriate treatment. I put this on here just because it's so difficult working with youth. They're different than adults. We can't just use our intensive outpatient model and just slap it on youth and say good luck. There needs to be some real careful consideration that goes into this. But this needs to be led by our treatment providers, and so I encourage if they would be willing to do any type of brown bag lunch or presentation at our staffing, a little short presentation about the different services that they have. I think that would be really helpful for the whole team to have a better idea about what the youth are being asked to do when they attend treatment and how it's specific to their adolescent development. There are also resources such as the OJJDP Tribal Youth Training and Technical Assistance to help you develop developmentally appropriate treatments. There's lots of resources out there and really neat things that tribes are doing in this area, including culture camps, equine therapy, all sorts of really cool stuff. So I apologize we're not spending much time on it. As far as the policies and procedures go, I think it's nice to give a little detail on what could be included, but it's not necessary to detail every single little thing and update it every single week. I think if you strive to do a 6-month or a year update of the new services that you have or ones that you no longer have, really good, so that people have an idea but that you're not bound by it. Finally, data. I was hoping that I wouldn't do this. I always do this. Poor data gets the short stick, but it sort of brings us around the circle, because one of the better ways to know if we're serving the community is to look at the numbers. Guideline 7.3 asks us to routinely collect the following detailed data, and I love that they do this. They actually tell us what we should be looking at. Our family-related factors. I don't know if any of you are familiar with this, but those of you involved with tribal social services, you may have a family assessment tool that you use to measure family well-being and functioning. There's a lot of really neat tools out there. I've most recently been working with, it's called the NCSAS, the North Carolina Family Assessment System, I believe it's called. It's a comprehensive web-based tool that tribal social services can use to measure family well-being. It's extremely comprehensive, and as I mentioned, it's specific to child welfare, but that may be useful for us in the juvenile wellness court. I encourage you to take a look. General recidivism or engagement with the juvenile justice system. Program completion. This includes any other programs within the wellness court, such as if they went to any curriculum-based program or a culture camp or a language class or anything like that. We should track how often did they go. Did they, quote, graduate or complete the course? Did they never show up? What did that look like? And here, as I mentioned, bringing us around the circle, how do we know that our community needs a juvenile wellness court? What does juvenile arrest rates look like? I encourage you, especially if you're within the court, pool this data for your court and take it to your next planning or staffing, just to show, what have the numbers been looking like? Do we have a sense about what drug is the most prominent drug in our community? Do we have a sense about what age range people are getting arrested for? Can we even answer these questions? Are we even tracking this? If we're not, today is a great day to start. I think a lot of tribes get freaked out that they haven't been tracking this and that it's too overwhelming, that they're just never going to be able to. You can start tracking this just anecdotally on your own. Creating just a little spreadsheet. I have sample spreadsheets that we've helped create for other tribes. Of course, some tribes have really comprehensive court-based systems that are brilliant. Some tribes have comprehensive court-based systems that are not brilliant, and then everything in between. Ideally, you're able to click a few buttons and produce a report for the last couple of years on these numbers and track what's been going up and down. But don't worry if you don't, because we can now. Similarly, does our clinic keep data on what their numbers are? Do they know how many people have been referred to their clinic for services? How many people have attended their services? How many people have completed their services? These are numbers that are not going to be in the court system. They're going to be in the Substance Abuse Treatment Center. And when you're accessing those, you're partnering with your treatment provider, they should be providing this numbers to you. It's declassified, as in you don't need participant-specific numbers. You just want overall numbers about what this looks like. The court and the treatment providers should be sharing this information. So we just covered some real highlights of just the policies and procedures. Some big documents that we didn't cover today include a wellness court brochure. I put this even before the participant handbook. As I've been working with more and more courts, there is a huge need for you to have a wellness court brochure. This is what you hand to all of your service providers so that when they meet a new participant, they can just hand this to them. What is the wellness court? Oh, here, let me tell you. Let me give you this cute little brochure. One page, just some contact information, and a couple bullets about what it is you're doing. You hand this to community members, tribal leadership, your partners. When you attend the enhancement training to other courts, this is the business card for your wellness court, and it's how you further legitimize that this is a real court doing real work. People don't know what it is. People don't know what wellness court means, and so your brochure helps to pacify and assure people what it is that you're doing. More comprehensively, your participant handbook. This is the policies and procedures for your participants. Many courts will just take their policies and procedures, maybe delete a couple sections that are, internal specific, such as what the roles are for each team member. But as far as the entry process, the phases, the incentives and sanctions, all of that should be communicated to the participant, but written in a way that the participant can read. So it should be, minimum 6th grade reading level. It should be really approachable, and it should be as short as possible. That said, a lot of participant handbooks are still pretty long, but you want to give your participant all the information necessary, but in a very accessible way. We talked a little bit today about interagency and interjurisdictional memorandums of understanding. Participant contract and waiver of confidentiality. These are documents at the entry level. Before a participant can join the wellness court, they agree to join and to sign that waiver, allowing the team members to discuss their case. Releases of information. Sometimes even with that waiver of confidentiality, internal procedures at like behavioral health or tribal social services will require a release of information. So whatever documents your agency requires in order to share information, that's what you want to make sure that you do. You satisfy your own boxes. Wellness entry court order. Maybe your tribal code requires a court order formally ordering someone to enter the wellness court. I put that on there. Some courts do. Some courts, just the referral from the case coordinator is good enough, and so that doing like a deferred sentencing is just fine. Applications for phase advancement. Some courts, in order for a participant to advance from phase 1 to 2, will require, okay, not only did you do all of the requirements for phase 1, but you formally submitted an application. It could be a good exercise, in the real world, there's paperwork that you have to file, so it's good to introduce that concept to our participants. But those might be documents that you might need to help prepare for your wellness court. So I put all of those on there just as sort of for our court coordinators when you're getting your wellness court ready, what needs to be in your file. These might need to be in there. They might not, but just wanted you to have access to those. These last couple of slides are some resources that I use to build this presentation that I've generally found to be helpful, so I'm just going to run through them real quick. These are juvenile specific. Our first one is tribal juvenile specific, made by our very own OJJDP TA provider. Very good. Again, all of these links are live. The second one are those guidelines, those research-based guidelines produced by OJJDP that I was talking about. And this third one is a really neat resource. This was made by the National Council of Juvenile and Family Court Judges. If you're still just building your juvenile wellness court, I really encourage you to take a look at this third one. It just has really good resources to go through. All of the same stuff that we were talking about today, I just really like how they put it together. This is the Wellness Court publication series produced by TLPI. None of these are juvenile specific, but they nevertheless may be useful to you. I would especially point to the treatment guidelines for those of you that are still building your treatment component. That has some useful stuff, as well as the policies and procedures guide. Also, the first one, the key components, that's our real foundational publication and the one that the Juvenile Wellness Court Handbook is based off of. So that also provides some good context. It also, as part of each component, has a anecdote from an operational tribe. I found those to be really helpful as well. Some foundational adult resources. The National Association of Drug Court Professionals put together a planning checklist. This is just like a 3-page document, but it has some good considerations for when you're putting your policies and procedures together. The Judicial Bench Book I go to all the time. It has great stuff. For example, this is what I would refer you to for your drug testing protocols and for your confidentiality chapter. Really good stuff on there. It is state-specific, though. So, for example, it has a whole chapter on due process. Well, only part of it is applicable to tribes because we have the Indian Civil Rights Act, not the Bill of Rights. And so some of it's applicable, some of it isn't. So I'd approach that chapter with caution. But other chapters are spot on, heavily researched, really, really good. Wellnesscourts.org is a website that TLPI has. We have resources for adult, family, and juvenile wellness courts, including a comprehensive webinar series, all free, available to you. I'll be posting this webinar as well as all the presentations from the enhancement training on here, so feel free to pick and choose all sorts of stuff. We also have the publication series on there. Treatmentcourts.org. This is a website produced by the Center for Court Innovation, and they have a whole webinar series on all sorts of stuff, including tribe-specific. If you have team members that are new to your team that haven't attended any training whatsoever, I would send them here. There's a whole bunch of really good stuff, and it's pretty user-friendly. You need to register your email, so it looks like, oh God, I need to pay for anything. It's all free. But they just want to be able for you to track your progress because there's a number of webinars, so you have to put in your email. So don't be scared. It's really good. And here's just some of the tribal-specific stuff that they have on there. This is another resource, National Drug Court Research Center, produced by American University. Just want to put this on here so you have it. It's all state-specific, and it's kind of not organized in the best way, but just wanted you to have it. And here's the National Council of Juvenile and Family Court Judges. That they've done a ton of research in juvenile drug courts. I would say they're probably the most prominent state juvenile drug court resource out there right now. They're doing a lot of good stuff. And that is it. I saved 5 whole minutes for questions, but I hope you have felt enabled to ask questions throughout the presentation. But please, if you have any questions now, we would love to answer.
Thank you so much, Lauren. And while we wait for people to type in questions if they have them, I just wanted to say that Pat is on. And I know for those of you that were in sessions 1 through 4, I know we want to say thank you so much to Pat for leading us through those sessions, and thank you so much to Lauren for this very informative session specific to tribal juvenile healing to wellness courts. And so we're really grateful to both of you, and the TTA Center just wants to say we appreciate the time that has gone into developing this series, and we're so grateful for all of you that were able to join. All 5 sessions of this series will be archived and placed on our website, and so if you have staff or team members that weren't able to join today, or you have partners or other agencies that you're going to develop agreements with, this will be archived and you can share this material with them at a later date, and we'll let you know once we archive it. We can let you know on the participant list that you can access this material. So we have, I'm going to check this question answer pod. I see Pat. I think you're not muted, Pat, if you want to jump
Okay.
on.
So I was just wondering, Lauren, if there's a model policies and procedures manual that the state systems use.
Ooh. No, I don't think there is. I would probably point to that judicial bench book again that the National Drug Court Institute produced. That's probably the closest that you could get to a model, but it just is like chapters for considerations. But no, I've never seen any model. Oh, you know what I didn't mention, though, is the drug court standards. That is a really good document for some research-based materials, such as like the drug testing and caseloads and team member roles. The National Association of Drug Court Professionals Adult Drug Court Standards. I'll put a link in the chat box. That is, again, the closest that I've seen to any sort of model.
Okay, cool. Thank you, Lauren. And I just wanted to say thank you to everybody else for sticking with me through the 5 sessions. I think someone's trying to weigh in.
I do want to say I appreciated several of the points that Lauren made, and especially with all the resources and information that we shared with you on the past webinars, and then today. You know, as this is a developing area, we do identify that not every suggestion fits every community, and I really appreciate Lauren sharing that it's really based on what's going to meet the needs of your specific community. And I know we've tried to share that off and on in the different trainings that we have, that we know that communities differ, that your staffing is going to differ, and so taking all of these resources and really looking at them with your team and making decisions about what's going to fit best for your community, and really trying to develop something that's going to be a good fit for your tribal youth. And so with that, I don't see there's any more questions. Does anybody have any last comments? Feel free to put those in the chat box. Otherwise, I did want to direct everyone to the webinar survey at the bottom of the screen, where we do take that feedback seriously, and so appreciate it. If you can fill out the survey, we would love that, and we can share that with our presenter today, so we appreciate any feedback that you can share. So Pat and Lauren, I just want to say thank you so much. I know I will get to see Lauren in a couple weeks at the training in Albuquerque, and so if any of you that are online right now are going to be there, hopefully we'll get to cross paths in person. I know webinar is hard to get to know somebody, and it's such a short period of time, so if any of you are there in person, I look forward to meeting you. And I think we have a presentation on Wednesday that morning, so I hope to meet some of you in person, and Pat, I hope to see you soon. I know you're all the way in Alaska, but we'll cross paths eventually, and so thank you so much for all of your hard work, and Lauren, thank you so much for sharing with us today.
Thank you, Anna.
Thank you. Well, hope all of you have a great rest of your week, and we're going to close out then. Oh, wait, we did have one last question. Cedric. Thank you, Lauren. Just a comment. Looking forward to seeing you at the training, and he's going to save some questions for on-site till he gets out there.
Uh-oh.
All right, guys. Have a great rest of your week. Thank you for being with us today.
Thank you. Bye-bye.
Bye, everyone.
Bye.